Hey, good morning, everybody. My name is Judge Kim Teresa Malika. You're in First Appearance Magistrate Court. Today, you're going to be informed of the charges, and we're going to determine if there's probable cause. Today is not your trial day. Please do not talk about the facts of your case. Everything is being recorded. You have a right to remain silent. You also have a right to an attorney. We have Mr. Romero, I believe, at the main jail, and we have Mr. Reedy to my right over here in the courtroom. If you have a private attorney, please let me know. We're going to take a couple cases at a turn. It's Ralph Charles Ippolito.
Yes,
Good
ma'am.
morning.
Ralph Ippolito, Mike Gottlieb and Clark Strandell on his behalf. Morning, Ralph.
Good morning. How are you, gentlemen? Nice to see
Thanks,
you again.
Judge, subject to your approval, we've had a discussion with the state. We're going to ask the court to set bond at $10,000 by agreement,
Okay.
and based on that, we'll agree that there's probable cause. I'm sorry? Page 15, Ralph Ippolito. You're welcome.
Okay. State, is that correct?
It is, Your Honor. I'd also be asking for orders of no victim contact, no firearms, weapons, or ammunition.
Okay, and the victim's initials?
CB.
Okay, perfect. So, you waive formal reading?
Yes, Judge.
Okay. All right, so $10,000 bond per the state and the defense. No victim contact, direct or indirect, with the alleged victim, CB. I want everybody to listen up. That means no contact in person, calling, texting, writing, nothing on social media, and no contact through third parties. Obviously, it doesn't include his attorneys. And no firearms, ammunition, or weapons. Thank you, sir. Good luck to you.
Judge, one concern, the incident allegedly happened at Mr. Ippolito's home. So I would just ask the state to caution the victim not to go, the alleged victim not to go to Mr. Ippolito's home. They were supposedly picking up mail or something there. Obviously, he has no intention of contacting them, but they were waiting outside his home according to the PC for several hours. So I would just ask them to please tell the alleged victim not to go to his home.
Well, I'm not really in a position to tell the alleged victim where he can or I don't represent him, and I'm not in a position to tell him where he can and can't go, frankly.
Okay,
All right.
we understand our conditions. Thanks, Judge.
Thank you. Have a good day. Okay, Robert Troy Lee Oglesby, please. Good morning, Mr. Oglesby. You have an out-of-state hold for a felony. It's a no bond hold. It's count 2. It's an ad charge. It's out of a state of New Jersey. We'll see you in extradition court, sir. We hold it Tuesdays and Thursdays at 1 p.m., okay? Thank you. Colleen Kearns, please.
I believe North Broward.
Okay,
She is in North Broward, Judge.
okay.
And she would like to resolve this case this morning if possible.
Okay, State, do you have an offer on Kearns?
One moment, Judge.
It's a trespass?
Where is she?
She's at North Broward, they're getting her.
Well, you offered me a withhold.
Good
Ms.
morning,
Kearns, I don't know if you heard, I'm sorry, Judge, go ahead.
No, go ahead.
Ms. Kearns, I don't know if you heard that, but the offer to you from the state is a withheld adjudication and court costs. It means you would not have a conviction on your record. Ms. Kearns,
Yeah?
are you interested in accepting that offer?
What does that mean?
It means you won't have a conviction on your record, but you have to pay some court costs. Judge, you give you
Sure.
time to pay.
How much time do I have to pay?
How much time do you need?
Give me a week?
How about 6 months?
6 months to pay the court costs?
Yeah.
Okay, and that's what, $100?
All right, listen to what the judge has to say now.
Okay.
All right, ma'am. So, Ms. Kearns, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, put your hand down. Is your name Colleen Kearns, Kearns?
Yeah.
It's my understanding through your attorney, Mr. Reedy, you want to give up your right to a trial? You don't want a trial, you want to admit to the charge today?
I mean, yeah, yes. I mean, I didn't get a court date. I didn't get the letter for the court date. I would have went. I mean, like, I didn't intentionally not go to court. I mean, I can pay that if you give me time to pay the $100 for, I mean, or however much you want me to pay, I'll pay it.
Okay, let's do this, Mr. Reedy. I think you need to talk to her a little bit more and find out what's going on. And
Yeah, I
make sure
did,
that
Judge,
you.
and I explained to her that, and we went over the dates when the capias was issued, which was on August 6th. You failed to appear
Yeah,
in court.
no, I understand. I mean, I would like to, what are my options? Like, I'd like to get out of here.
All right, let me tell you first, ma'am, you have a capias misdemeanor for trespass property, other structure. Judge Hurley set a $1,000 bond because you allegedly have failed to appear in court.
Okay.
So, we're here today, we're going to determine if we should keep that $1,000 bond in place, or if you want to admit to the charge today.
I can admit to the charge.
If you want to admit to the charge, then the plea offer is a withhold of adjudication and court costs of $293. If you don't want to do that, then you can always come back and fight your case, and we can talk about the court will ROR you, so you can come back and fight your case. If you, listen to me, ma'am, if you feel you're not guilty, then you can be released today, but you'll have to come back and fight the charge. If you don't show up to court and you're released, then you're gonna have another capias and you're gonna get rearrested again. So your options are, come back, be released today and come back and fight your case, or you can admit to the charge today. What would you like to do?
I mean, I'll fight the case.
You wanna fight the case? Okay, no problem. So what's your mailing address, ma'am?
4655 Bougainville Drive.
All right, I'll ROR you. Look for your court date. If not, you're gonna have another capias. Thank you, good luck to you. Next one is Jai Lee, L.I.
I'm waiting to hear back about the availability of a Chinese interpreter.
He was here, Judge, yes, we called for an interpreter.
Okay, so we'll recall. Next one is Joanna Lynn DeLeon Colonna.
Yes, ma'am.
Castiglione Colonna is represented by Ken Padowitz, Judge, if I could have a few moments to try and reach him. Hey, yeah, I don't know if it's Mandarin or
Okay, so someone's gonna reach out to your attorney, Ken Padowitz, okay, ma'am?
Yes.
Have a seat.
Thank you.
Gasha Decius, Decius,
We
please.
also need Spanish.
Well, Robert, she was released, Your Honor.
How was she released?
Well, her dad was here yesterday, Your Honor. I think he might have bonded her out.
Oh, okay. So bonded?
I believe, yes.
Okay. Okay, there you go. Next one is Daniela Greenfield. Daniela Greenfield. Thank you. Good morning.
Good morning.
All right, ma'am, you have an ad charge, capias felony attempted robbery with a weapon.
Yeah.
Court does find probable cause. What say you, state?
Your Honor, I'm on the attempt, because she's also being held on a $50,000 bond with bond plus a GPS for robbery with a weapon. I'm gonna be requesting a $10,000 bond plus pretrial GPS.
You know, I spoke with Ms. Greenfield earlier, Judge, and the $50,000 bond, which is not before the court this morning, is out of reach. So she's going to have to go in front of her division in any event.
Okay, so $10,000 bond, any no victim contact or anything, state?
I believe it was already issued, Your Honor, but if you want to issue it again,
I'd like to do it on this charge, please.
Sure.
Just in case something happens with the other charge.
Your Honor, I don't have the initials in front of me, but I believe I provided you the information, and it should have the victim's
Okay.
name in the second charge.
Okay, I just have the two persons' name and the last name. No contact, direct or indirect, with the alleged victim with the initial, well, not the initials, the last name is Synagal, Synagal, and Araguz, Araguez. These are the alleged victims in the case. No contact means no contact in person, calling, texting, writing, nothing through social media, and no contact through third parties, whether you're in jail or not. This court's gonna set at that $10,000 bond. Thank you, ma'am. Good luck to you. And then the next one is gonna be her co-defendant, who was on page 18, who is Dwayne Tyrone Brown, please. Is he at the North Broward or main jail?
Your Honor, he's Conti, but he's not up here just yet.
Okay, so let me know and I'll recall him.
Yes, ma'am.
Thank you. Crystal Renee Gary, please.
Medical reset.
Okay. Alexis Everett, please.
He's approaching, Judge. He's here at Maine.
Yes.
This is the receiving facility this morning. See how the communication time served to the right? Your hammer. The clerk came back and put withheld in the middle of the charges, and then on count 7,
Okay.
adjudicated time
Can we
served
talk
is-
about this after I'm done with this?
They're gonna miss the thing. You want them to video?
All right, let's take a brief recess. Alexis Everett, please. Does anybody know where Alexis Everett is?
At Maine, Judge. She's approaching.
Okay. All right, Miss Everett, good morning, ma'am. You have burglary, unoccupied structure, unarmed. And then you have grand theft between $300 and $5,000. Then you have criminal mischief, $200 or less. Bonds on 2 and 3 are $1,025. And then count 1 we need to talk about. State?
Your Honor, because this involved a business and based on the strength of the evidence, it was captured on video and she was identified by the 2 victims that she's personally known to, I'll be requesting $5,000 bond, no return.
No victim contact?
Yes.
Okay, defense?
Judge, in speaking Miss Everett, she's 19 years old. She's been here her whole entire life. She's a graduate of Fort Lauderdale High School, class of 2017. She just graduated. She is working. She works at the Hampton Hotel in the housekeeping department. She's been there employed for about 1 year, making $9.25. She lives in Fort Lauderdale with her mother. Her mother works at Walgreens, so that's the person that's she can contact to help post her bond. Judge, my understanding is this is her first arrest. She's a voter here in Broward County. At this time, she's currently speaking with an Army recruiter. That's her goal, to join the Army and serve the United States Army. Judge, I'd ask you, considering if the judge can Mr. Lender can verify that this is her first offense, I'd ask you to consider an ROR. If not, Judge, I'd ask you to go ahead and impose a bond of $1,000 on count one.
No history, Your Honor.
Okay, so the court does find probable cause. Court's going to order no victim contact, direct or indirect, with the alleged victim with the initials SMM and SNM. That means no contact in person, calling, texting, writing, nothing on social media, no contact, which means passing messages through third parties, okay? And then you have no return to She's Wigging It, that's the name of the store. Court is going to set a bond on count one at 1,000, count two at 1,000, and count three to court a ROR. So that'll be a total of $2,000. Thank you, ma'am. Good luck to you. Okay, next one is Ordenica Mullings.
North Broward, Your Honor.
Good morning, ma'am. How are you?
Good morning, Judge. I'm okay.
All right, ma'am, you have burglary with assault or battery. It's a no bond hold. The court does find probable cause. What say you, State?
Your Honor, the state is going to be seeking finding a proof evident or presumption great for first appearance purposes only and no bond hold based on the allegations, specifically the allegations that Ms. Mullings, once she, after unlawfully entering the home, that she armed herself with a gun and then after that armed herself with a knife.
Okay, defense?
Yes, Judge, I would object to the court making a finding of proof evident presumption great at this stage of the proceedings based on a probable cause affidavit. Proof evident presumption great is the highest standard that we have in criminal law. And I do not believe that standard is met by this probable cause affidavit, in which the only testimony given is that of the alleged victim in the case. It does appear from Ms. Mullings' statement that she did enter the residence. She is looking forward to her day in court. This was a fight. It was not as one-sided as this police report written by an officer to justify the charges that he's placed against Ms. Mullings is going to support in the long run. I believe that she has a very good defense to this case and will be raising that eventually and should not be held without bond at this stage of the proceedings. Also, if the court is inclined to find proof evident presumption great over our objection, I would urge the court to consider exercising its discretion and set bond for Ms. Mullings in any event. I'll have further argument on that depending on the court's ruling.
Okay, so Ms. Mullings, you are charged with burglary with assault or battery. I have reviewed the probable cause affidavit filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, ma'am, you're going to be held without bond until further order of the court. This order, ma'am, is without prejudice. For you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. I'm also going to tell you, I didn't know if you heard my beginning statement, today's not your trial day. Please do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. And you also have Mr. Reedy, who's representing you in the courtroom today. So you're going to be held no bond. Good luck to you.
In reference to the court's exercise of discretion, I think the court should be aware of certain facts.
Sure.
Ms. Mullings has been a resident of South Florida for 10 years.
Right.
She lives by herself. She has never been arrested before. She's been living at the same residence for the last 4 months. She's provided me with the names of several friends who could possibly raise bond if a bond was set. She received injuries herself in the course of this incident, and we are going to be asking the court to sign a photo order for her. And once again, we would urge the court to exercise its discretion and set a bond for Ms. Mullings.
Okay, the court's going to keep the no bond hold in place. I appreciate your argument. Thank you, Mr. Reedy. But these are very serious allegations with a handgun and children, young children inside a residence. So court's going to keep no bond, no victim contact, direct or indirect, with the alleged victim with the initials MY. That means no contact in person, calling, texting, writing, no messages, even if you're in jail, through third parties. Thank you, ma'am. Good luck to you. Okay, we have a private attorney here for page 7, Robert Michael Santora.
Yes, Your Honor. Actually, I am standing in for Attorney Jara McLawrence from the City of Fort Lauderdale Public Defender's Office. Your Honor, I went over to the main jail to speak to Mr. Santora, and he did indicate that he would not like our services. He'll like to hire his own attorney. He does not want an attorney appointed to his case. So I just wanted to bring that to the court's attention. He is at main jail.
Okay.
Main Judge.
Okay, so Mr. Santora, good morning, sir.
Good morning.
Okay. Mr. Santora, you are charged with, you have a capias for trespassing. Says you no-showed at arraignment. You have a $500 bond. You want to hire a private attorney, sir?
Yes, ma'am.
Okay, so you want to fight your case?
I'd like to.
Don't talk about the facts of your case, though, okay? I just need to know, do you want to fight your case and come back to court? You want a trial?
I would just like to be released as every time so far.
State, what's his prior history?
One moment. This is just the docket. I see an arrest July 26th of last year. Trespass, same
Hold
location.
on, sir. I'm sorry, what'd you say?
July arrest last year for a trespass at the same location.
Same location?
Yeah. October 2015, KP on a municipal ordinance, sleeping on a bench, municipal bench. 2013, KPS, urinating in public. 2013, disorderly intoxication, obstruction. 2012, sleeping on a municipal bench. 2012, KPS is on two separate, I'm sorry, those are sleeping on beaches. 2010, KPS sleeping on beach.
Okay, so he has a lot of failures to appear.
A few.
All right, sir, so how much can you said that you're gonna hire a private attorney. How much can you afford in bond?
I cannot afford in bond at the moment, but can pay after release.
So this trespass that he's charged with, state, is something, place that he was trespassed before, you're saying, last year?
As a friend of the court, Your Honor,
I understand.
according to BSO Pics, he was arrested last year in a trespass, and the arrest location is identical to the location here.
What's the location?
That
Is it City Hall or?
Actually, you know what? One moment, Your Honor. Let me check. I didn't realize this was a KPS because it's identical to where he was arrested when they served the KPS. I don't know if it's a location he was originally trespassed from.
Sirs, what's your mailing address? Do you have one?
Yes, 3873 West Commercial Boulevard.
Tamarack?
Yes.
Is there an apartment number attached to that?
I believe it's 2 or 3, but I'm not sure.
Okay. If it's just addressed to the 3873 West Commercial, is it gonna get there?
It'll get there.
Okay, Your Honor, where he was arrested when they served the KPS is the same location he was trespassed from, same location as the offense last year, Casa de Angelo. Well, it's the shopping center where Casa
Let
de
me
Angelo
read the
is.
PC, because I just. Okay, so he issued him a notice. Okay, sir, so you were given a notice to appear and then you failed to appear. So what is it that you're asking the court for today?
To be released so I can get a private attorney.
All right, this is what I'm gonna do, sir. Since you failed to appear and you were given notices, I'm gonna put you on standard pretrial supervision. Can someone at the main jail give Mr. Santora a map? And also, sir, on August 23rd, I'll have them write it down for you at 10 a.m. You have court before Judge Melinda Brown. You have to appear. Can you write that down for me, Mr. Romero? I'd appreciate it.
October 23rd?
I'm sorry, August 23rd.
Oh, August 23rd.
Sorry about that, at 10 a.m. I was looking at the 10.
10 a.m.
And that's Judge Melinda Brown. It's the 5th floor. Okay, sir, if you don't show up, you're gonna have another warrant for your arrest. And then, you're not gonna be able to, be released out of jail. So, you gotta make sure you show up. And you have to report to pretrial services. You have to call in twice a week, report once a month. You have to definitely be, report within 24 hours of your release, okay?
Okay.
Thank
Fine.
you. Good
Well,
luck,
within
sir.
24. Thank you.
You're welcome. All right, Counselor. So, the next,
Your Honor,
yes,
Conti,
yes, sir.
I got Mr. Brown.
Okay, perfect, thank you. Oh, you're welcome, no problem. Okay, we have page 18. We now have Dwayne Tyrone Brown. Good morning, sir. You have a change of charge, count 2, for attempted robbery with a weapon. Court does find probable cause. What say you, State?
Your Honor, Judge, I believe it was, I'm not really sure who was the judge at his first appearance, but bond was set at $50,000, pretrial release level 1 GPS, no victim contact, no weapons. Because it has been changed to an attempt, I'm going to be requesting a $25,000 bond with the same conditions. Just need to, based on the allegations, Your Honor, and
Yeah, I don't know who that is that did the $50,000 bond. Here we,
Judge
Bowman?
Judge-
Okay, thank you.
his criminal history, 2017, uttering a forged instrument and grand theft, 2015 theft, 2015 disorderly conduct, false fire alarm, 2013 carrying concealed weapon, loitering and prowling.
Okay, defense, what say you?
Judge, obviously I did not have a chance to talk to Mr. Brown because they just brought him down. If I could have a couple of minutes to do that, I'd appreciate it.
Sure, we'll go off the record for a moment. Okay, let's recall Dwayne Tyrone Brown. Have you had enough of time, Mr. Reedy, to speak to your client?
I have, Your Honor.
Okay.
Mr. Brown is basically in a position to not post any type of monetary bond right now. Our office does represent him. Skylar Hill is his attorney. I'm gonna contact her and ask her to set him for a bond hearing in front of Judge Fine. So I'd be asking for, what were you asking for, Mr. Linder? 25?
25, cutting it.
I'd ask for 15, Judge.
Okay, the court will set bond at $15,000 on the robbery attempted with the weapon. No victim contact, direct or indirect, with the alleged victim with the initials MS and AA. That means no contact in person, calling, texting, writing, nothing through social media, and no contact passing messages through third parties. Court's also going to order no return to the America, AMERIKA, gas station located at 1493 Northwest 31st Ave. Looking what town this is, state. I only have the reporting officer narrative.
Pompano Beach.
In Pompano Beach, Florida, sir. Thank you very much. Good luck to you.
We were requesting that he keep the GPS level 1 on him, Your Honor, that Judge Bowman said.
Okay, GPS level 1. Thank you. Okay, Madam Clerk, make sure all these papers are attached. Thank you. Okay, next one is Goose Hen Who, H-U.
Same situation, Judge. We're waiting for an interpreter. And I'm not.
Yes, Judge, and she's at the main jail.
Do you know if it's Mandarin or,
We can't find out.
okay,
But I have been in touch with the interpreter's office, and
Okay,
they're
great.
gonna try and
All
work
right.
with us as best they can.
yeah, we'll figure it out. All right, Christine Trapberger, please.
North Broward.
All
Oh, I'm sorry,
right.
Paul Ryan. Paul Ryan.
Okay. All right, Ms. Trapberger,
Good morning, Your Honor.
good morning. You have abuse of a child without great bodily harm. The court does find probable cause. What say you, state?
Your Honor, I'd be requesting a $2,500 bond and no victim contact.
Hey, defense?
Judge, I'd be asking for a pretrial release as an condition of ROR. Ms. Trapberger has lived here in Florida for 30 years. She has no prior criminal history whatsoever. The alleged victim in the case can stay with her ex-husband, so there'll be no need for any contact between the two of them. She is currently in school at Broward College studying business. She has been working for the last 2 to 3 years at Food for the Poor as a coordinator. She's been living in the same residence for the last 5 years, and she's not at all certain she's going to be able to get anybody to post a monetary bond for her in light of her lack of a prior record, strong ties to the community, and that this is basically a fight with her daughter. I would ask the court to consider pretrial release and ROR for Ms. Trapberger.
State, any response?
Well, if Mr. Reedy is saying it's a fight and that, yes, it was a verbal argument, if he's insinuating that this was mutual combat, there's no allegations to support that.
I don't remember making that claim.
I
said
just
it
didn't
was
know
a
when you
fight.
said it was a fight, I didn't know.
Well,
Verbal or it could be physical.
According to the probable cause affidavit, it's a fight, so. I don't know how else to describe it.
All right, well, the court is going to order no victim contact directly or indirectly with the alleged victim with the initials ISE until further order of the court, whether it be the division judge, a family or dependency judge. Court is going to do standard pretrial supervision. She has no prior history, correct, State?
No, Judge.
Okay, no prior history. So ma'am, they'll give you a map. You have to report within 24 hours. And also, you'll have to call in twice a week and report once a month. Let me just verify your address. Hold on. Your address is 3593 Wiles Road, 306?
Yes.
Okay, look for your court date in the mail, and you might want to reach out to the public defender to see if you qualify for their services before your court date. Thank you.
Thank you.
Good luck.
Thank you.
Pitney or Brittany, what is it, a B or an H? I can't make it out.
It's
Bitney?
actually Bitney,
I think it's a
B-I-T-N-E-Y.
typo, it should be Brittany.
Huh?
It's a typo, it should be Brittany.
Okay, Brittany Wilbur, please.
She's in North Broward, Judge.
North Broward, okay. Okay, good morning, Miss Wilbur. How are you?
Good. How are you, ma'am?
Fine, thanks. You have DUI, alcohol, or drugs, second offense, $1,000 bond. Count 2 is DUI with damage to property of person of another. 2 counts, $1,000 bond each. Count 4 is DUI with unlawful blood alcohol level above a .15 and failure to stop and remain in an accident involving non-serious injury. We need to talk about bond. The court is gonna, does find probable cause, and the court is gonna order no victim contact, direct or indirect, with the alleged victim with the initials MS. That means no contact in person, calling, texting, writing, nothing on social media, liking, disliking anything, or the like, and no contact through third parties. That means no passing messages, whether you're in jail or not. State, what say you on count 5, please?
Excuse me, Your Honor. I'm gonna be requesting a $3,500 bond on count 5.
Okay, what's her prior history?
Disorderly conduct out of Montana from 2016.
Thank you.
And the possession of fentanyl derivatives that she's currently in drug court on.
Where here?
Yes, in front of Judge Tobin Singer. That's count 8.
Okay, defense?
Judge, I'd be asking for a $1,000 bond on count 5. As Ms. Wilbur and I discussed, she's not going to be released until she goes in front of her division judge based on the capias in count 8. Our
Oh,
office
wait,
does
there's a
represent
second
her.
page. Hold on. No, I don't have count 8.
There's a count 8 is a felony capias, not for magistrate.
Hold on a second. 6, 7, and 8 did not print on mine. I only have 1 through 5.
6 is a reckless driving.
Yeah, I don't know why that didn't print out. Let me just put it here. 6. Reckless.
Count 7 is a failure to give aid. Count 8 is a
Well,
no
that's
bond.
not for magistrate, and then the
Not-
KP is
that's true,
felony.
That's not for magistrate, and count 6 is no need to post a bond, it's an NC.
Failure.
Count 8 is a no bond capias.
Not for magistrate. KP is felony, not for magistrate, no bond hold.
Correct, Judge. That's why I'm asking for a $1,000 bond. It's consistent with counts 1 through 4.
Okay. All right, so then this is what the court's gonna do. Keep all the bonds in place, and then on count 5, the court's gonna do a $1,000 bond. The reckless driving, Sheila, it's an NC, so no charge. Failure to give aid is not for magistrate, and then the KP is felony is gonna be a no bond hold. All right, thank you very much. Good luck
Judge,
to
we're
you.
also gonna ask you to sign a photo order on this one.
Sure. Okay, we have another private attorney here. Hi, let me find your case. Delion Kelowna, I don't know if we did this one already.
We placed it on recall so that Mr. Padowitz's office could be contacted.
Correct,
This
Judge.
sheet, it was ready.
Here you
Yeah,
go,
yeah,
Ms.
yeah.
Okay,
Patrice.
great.
Thank you. And Judge Christina Cassie Kuzmich, I'm standing in for Kenneth Padowitz, who will be attorney of record on this. I'll wait till the court's ready. Good morning, Ms. Colonna.
One moment. Okay, are you Joanna Lynn DeLeon Kelowna, ma'am?
Yes, ma'am.
All right, you have your attorney here or someone from your attorney's office. You have a DUI third offense over 10 years, $1,000 bond. Count 2 is refusal to submit to a DUI test. There's no bond attached to that. It's essentially an ROR. And count 3 is an open container or improper stand, park, vehicle. That's not for magistrate, so that's just a civil traffic infraction. So the court does find probable cause. What say you, defense?
Judge, I would first inquire, Ms. DeColonna, can you afford the $1,000 bond?
Yes, my mom posted the bond last night.
Well,
Let's see if she bonded. How did your mom post it? Cash or a bondsman? Do you know?
A bondsman. A bondsman.
I don't know if counsel's done. I'll wait.
Well, Judge, in light of the fact that the bond was posted, I would, in this situation, ask the court to keep it that way and just, when her bond is posted, then she can bond out.
Okay.
It has not been posted? Okay.
So
Ms.
you might want to give a call to the bondsman and,
I'd like to address the bond, Your Honor.
okay.
Your Honor, I'm requesting a $15,000 bond. Ms. DeLeon Kelowna is a danger to the community. In this case, she, while driving under the influence, she was witness to driving into mailboxes, driving over curbs and medians, going into oncoming traffic and nearly sideswiping other vehicles.
As stated in the probable cause. Go ahead.
Stated in the probable cause. She's out right now on 2 DUIs. She's out on a felony DUI with property damage from a 2016 felony case, and she's out on a DUI enhanced breath on a 2018 misdemeanor case. Now, it's going to be up to the court to what action you take on those matters sua sponte. She is a danger to the community. She also has a DUI from 2005, and I imagine she has DUIs prior to that because the 2016 has been charged as a felony. There's no reason to believe that if she's released out of custody on any conditions, that she will not get behind the wheel under the influence. And frankly, she's putting every driver, when she goes down the road, she's putting every driver in Broward County's life at risk.
Your Honor, may I respond?
Sure.
If the court's inclined to agree with the state's argument, Judge, I would ask that you leave the bond the same. And if the court wants to impose maybe an electronic monitoring, I think Ms. DeColonna would be obviously inclined to do that, or maybe like a scram bracelet or a condition of not driving, Judge. I think at the end of the day, Your Honor did read the probable cause affidavit, and so I know the state did cite to some of the things already listed in there. I think the bond, having possibly been posted already with an electronic monitoring, some kind of scram bracelet would be sufficient, Judge. I don't think there's anything that indicates that she's a danger to the community. This just seems, I don't want to minimize it, but per the probable cause affidavit, it is a DUI.
Your Honor has DUI manslaughters all the time before you, and frankly, she's already out on 2 DUI cases,
That are pending?
both pending, Your Honor. And frankly, I don't believe that the court can have confidence in that putting a TAT or scram monitor on her and hoping that she won't drink and she'll follow that. Like I said, the only condition at this point that I believe the court can have confidence in ensuring the safety of the community is keeping her in custody on her 2 pending cases. But that will be up to the court sua sponte.
Judge, I will let the court know that Ms. DeColonna was in a treatment facility. I'm sure she could probably go back there. And again, my argument would be, Judge, that with some kind of electronic monitoring, a scram bracelet, and back in that facility, she's off the road, Your Honor, if in fact these allegations are true.
Court is gonna order no driving until further order of the court in any.
Rehab's not permanent. As you can see, her felony case is a 2016 case that's been going on for 2 years. Even if she went into rehab tomorrow, at some point she's getting out, and the same concerns are there. This has been an ongoing issue, and it's not just the 2 pending cases. She has DUI convictions prior to that.
What's her pending cases? What are those numbers?
16-489 CF 10A, to wit, the defendant is being supervised by pretrial services.
Yeah, bond and pretrial.
Yeah, and bond, yes.
What was her bond?
1,000 on each count, I believe. Yes. It's 1,000 on the DUI third offense over 10 years and DUI property damage, 1,000 each count. And when you're ready, Your Honor.
Go ahead.
The misdemeanor is 18-13547 MU 10A. That's a DUI enhanced breath and DUI.
All right, so this is what the court's gonna do. On this case, court is gonna do a $10,000 bond on count 1, considering she has 2 other cases pending. Court's gonna order no driving until further order of the court. Court is gonna order a TAD monitor. And as far as 16-489 CF 10A, $1,000 bond was to which one?
It's 1,000 on each count.
How many counts are there? Is what
2.
I'm, and it's DUI and what?
But it was a misdemeanor at the time when the $1,000 bond was set,
Well, how did it become a felony?
because they had the priors wrong.
Okay. So 16-489 CF 10A. Court is gonna revoke her pretrial status and do a no bond hold on that one. She can go before her division judge. I think they need to take a look at this.
Understood,
And then
Judge.
in 18-13547, MU 10A. You know what, the court's not gonna take, let's let the felony judge figure it out, and she's on pretrial for that.
I think that was just the bond on the misdemeanor.
That's the no bond.
Let me see that
you
one.
just-
Let me see the misdemeanor one.
And that's the new one. I don't have the misdemeanor one.
Your Honor, the misdemeanor, it appears she posted bond prior to her first appearance.
All right, so, you know what, I'm gonna, let me pull up this case, I wanna see this before I do anything. This one is the same charge, obviously. It says DUI, third offense over 10 years. And this is DUI, third offense over 10 years.
And that, in Your Honor, I just would bring to the court's attention, it may be, frankly, it may be over 10 years now because of when her prior convictions were. Her last arrest, the felony arrest, because of when it was, her convictions might have been, or at least the most recent one, might have been within the 10 years.
Okay, but she has a pending, and it says she was incoherent. So based on all of the information the court has, I'm gonna do, revoke her pretrial status in 16-489 CF 10A, and do a no bond, let her go before her division judge.
Do I still get bond?
No, you're gonna have to go before your division judge. You can talk to your attorney in just a moment. Give me one moment. And then, all right, so in this case, count one, I'm gonna do a $10,000 bond. No driving until further order of the court, TAD monitor. And you have two pending cases, the 16489 CF10A. Court's gonna revoke your pretrial status and do a no bond hold. And in case number 1813547, the other DUI, court, MU10A, court's gonna also, revoke your bond and do a no bond hold. So, that's
So
it.
I can't bond out?
No, you can't, ma'am.
Miss
So,
Colonna,
tell you
sorry,
what, go to the left, ma'am, and, your attorney will call you in one moment, okay? Mr. Reedy, if you could dial, North Broward,
Thank you, Judge.
thank you.
We'll speak, Miss Colonna.
Oh, and I also am gonna put a TAD monitor on her, okay? Okay, Tatiana Della Rosa. Tatiana Della Rosa, please.
She's a medical loan judge.
Okay. Thank you. What about Bianca Estrella?
I believe she's still a medical reset as well.
Okay. Irene Martinez.
She's here present with us, Judge, at Maine.
Okay. All right, Miss Martinez, good morning. You have possession of cocaine. KP is misdemeanor, $1,000 bond, $100 bond, and then you do have an out-of-county hold for a felony. You have a no bond hold. Court does find probable cause. What say you, defense?
Judge, and speaking Ms. Martinez, I believe that out-of-county hold is Dade County. She advised me that she's already contacted her friend. Her friend is going to be posting her bond, so she'll be released from Broward and taken to Dade.
So leave the bond, and then she has a KPS misdemeanor for loitering and soliciting.
Oh, that's a municipal ordinance, so I have nothing to say
Oh,
on
it is
that.
an MO case. All right, so let's pass for Mr. Shea. Sorry, I didn't realize that, so we'll have to pass it and come back to it. Thank you. Tashome Kwame Dawes.
Mr. Dawes, Judge, he's here present at Maine. He declined the service of public defense.
Okay, Mr. Dawes, you realize that if you have a right to an attorney, and if you can afford an attorney, the court will appoint a public defender for purposes of today. Do you want to represent yourself? Do you have a private attorney, or do you want the court just for purposes of today to appoint the public defender?
I'm going to represent myself.
Okay. All right, sir, you have an assault on an officer, firefighter, EMT, $100 bond. Count 2 is petty theft, second degree, first offense. There's no bond attached to that. And then you have a resisting an officer without violence. No bond attached to that. Court does find probable cause. Total bond is $100. Is your mailing address, sir, 1705 Southwest 14th Court, Fort Lauderdale?
Currently, it is not.
Okay, do you have a mailing address?
Yes.
What is it, sir?
1660.
6060?
1660 Northwest 113th Avenue. Pembroke Pines, Florida. 330.
I'm sorry, it cut out. 33 what?
026.
Let me read this back to you just so I'm sure, okay? 1660 Northwest 113th Avenue, Pembroke Pines, Florida, 33026. Is that correct?
Yes.
All right, can you afford the $100 bond?
Yes, ma'am.
All right, do you have the person's phone number?
I have my debit card here.
Okay, so you're gonna self-bond?
Yes.
Okay, and no return, sir, to Champions Cafe, okay? Good luck to you. Look for your court date. Okay, next one is going to be Eric Lopez de Victoria, please.
Municipal ordinance,
All
Judge?
right, thank you.
There is one misdemeanor on there.
We're gonna recall it. Steve Gilbert, I gotta get in the habit of looking at the case numbers. Steve Gilbert, please.
He's here at me. Yes.
Good morning,
Good
Mr.
morning.
Gilbert. You
Good
have
morning.
driving while license is suspended, second offense, $100 bond. Counts 2 and 3 don't require any bond, leaving the scene of a crash involving damage to property and failure to register a motor vehicle. Counts 4 and 5 are civil traffic infractions. Counts 4 and 5 are civil traffic infractions, failure to provide proof of liability, security, and following too closely, which actually aren't from magistrate, they're civil traffic infractions. Court does find probable cause. What say you, defense?
Judge, he advised me that he's gonna self-bond. He has, the money in his property, so he's gonna self-bond, Judge.
All right, and let me just confirm his address is 770 Northeast 43rd Court, Pompano.
That is correct, Judge.
All right, and the court's also gonna do no victim contact, direct or indirect, with the alleged victim in this case, with the initials CB. Do you understand what that means, sir? Or do you need me to explain it? I don't mind.
No, I understand.
All right, thank you, sir. Good luck to you. Travis Williams.
North Broward.
Good morning, Mr. Williams. How are you, sir?
I'm all right, how are you?
Fine, thanks. We have Mr. Reedy who's representing you in the courtroom here today. You have a capias for petty theft between $100 and $300, value bond set at $500, and resisting or obstructing without violence for a $500 bond, total of $1,000. Court does find probable cause. What say you, defense?
Your Honor, Mr. Williams would like to resolve these charges today if possible.
Okay, State, do you have an offer?
Be a withhold court costs and no return to.
Pardon?
One moment, Your Honor, I apologize. I'm just trying
That's all right, take your time. Does he want to withhold in court costs and no return?
Mr. Williams, if you want to resolve your case today, the offer from the state is a withheld adjudication, which means there would be no conviction on your record, but you would have to pay court costs. If you fail to pay the court costs, that could have an effect on your driver's license, and it could also affect your credit. As I told you before, if you pick up 3 petty theft charges, the 3rd petty theft can be filed as a felony. Do you understand that?
Yes, sir.
Understanding all of that, do you want to give up your right to a trial, enter a plea of no contest, and resolve your case this morning, receiving no conviction and court costs?
I would like to be somewhat released, because I didn't have transportation to go to my court date, because I'm homeless and I really don't have nothing for me to do. So
I can advise the court that Mr. Williams has lived here all of his life. He did indicate to me that although he's homeless, he has the ability to stay with his mother. Unfortunately, his mother's phone number and address are in his property, I think, based on my conversation with him. If he would prefer to come back tomorrow afternoon, I could ask the court to sign a property order allowing him access to his property, if he can come back with his mom's address or something, or if the court was thinking of releasing him today, or an ROR or pretrial release, if that's what he wants. He indicated to me he wanted to resolve the case, but if he's had a change of heart, I mean, that's strictly up to him.
is it possible that I can be released and come back at a later time? Because I was supposed to move to Pensacola on Saturday, and I'm supposed to come back for the rest of my stuff, so I could see court. I come to court when I come back, or something.
Well, this is the problem, sir. It doesn't work like that. I mean, you said you couldn't get a ride last time or, get to court. And, I don't see anything here indicating whether you requested, it was August 1st it was issued.
And Judge, just so the court's aware, he also has a warrant out of Dade County for failure to appear in a theft.
All right, so this is what I'll do. I mean, I don't want him to admit to a charge he doesn't want to admit to. Where's the no return to?
Four Rivers Smokehouse on North University Drive in Coral Springs.
Okay, sir, you're not to return to the Four River Smokehouse, Coral Springs. What are we gonna do since, the court has concern, he's moving to Pensacola, but he didn't show up last time, and it's gonna even be harder for him. Then he's gonna be up in Pensacola. So, and I don't blame him for not, I don't wanna, penalize him for not wanting to resolve his case. That's fine, I get that.
He's gonna have to come back from Pensacola. We had this conversation before court, and I mean, these cases are not being transferred to Pensacola, because Mr. Williams had inquired about that. You're gonna have to come back here, Mr. Williams.
Yeah, I understand I have to come back. I told my mom, and my mom said she's okay with coming back whenever court days issued.
All right, well, here's the thing. I'm gonna put him on standard pretrial supervision. So he's gonna have to call in 3 times a week. And he can find out, no return to the Four River Smokehouse, call in 3 times a week. And sir, you have to report within 24 hours of your release to pretrial services. If not, you're gonna have another warrant out, and then you're gonna go down to Dade, and then you're gonna come back up to Broward. So, how is that gonna work when now I'm RORing him?
I don't see the Dade County warrant here.
Unless someone can interview him in pretrial services, because do you have a Dade County warrant, Sheila?
It's Dade County pickup only.
Okay, all right.
You need to get down to Dade County and straighten that out, Mr. Williams.
Yes, sir.
All right, so standard pretrial supervision, report within 24 hours, call in 3 times a week, no return. Thank you, sir. Good luck to you.
Thank you.
Yes. Yes. Dwayne Vinton Milligan,
He's approaching, Judge. He's here at Maine.
and he doesn't have to report in person once a month. Ms. Patrice does not. Okay, are you Mr. Milligan, sir?
Are you Mr. Milligan? Yes.
All right, good morning, sir. You have petty theft, first degree property between $100 and $300. Court does find probable cause, bond set at $100. Court is gonna order no return, sir, to the Walmart at 1800 South University Drive, Miramar, Florida. What say you, defense?
Judge, it's being Mr. Milligan. We're going to be asking Your Honor to consider an ROR on his behalf. I'll see if the state has an objection.
They do. So,
Judge, he's 30 years old. He's been living here for the past 2 years. He's currently employed. He works for Elite Garden as a security guard. Judge, he's advised me this was a big misunderstanding. Judge, we're asking you to consider this as a misdemeanor, nonviolent offense, to consider an ROR on his behalf.
Your Honor, ROR'd him 2 weeks ago for amphetamine and cocaine.
okay, I ROR'd him 2 weeks ago and he's out getting arrested again, so I'll put him on standard pretrial supervision.
Thank you, Judge. And he's being handed a map right now.
Thank you. He has to report once a month, call in twice a week. Okay, Mr. Shade, come on up. Let me call, we have,
And on page 8,
Well, this is the first one I have, is Irene Martinez.
Ms. Martinez is approaching, Judge?
I think this is yours.
What page would she be on, do you know? I didn't see that. Oh, I see, she's got a possession of cocaine as well, Judge.
Yeah, she has an MO 40, so that's yours, Hollywood. So loitering, soliciting, act for prostitution. All right, so ma'am, you have a possession of cocaine, $1,000 bond. You have a capious misdemeanor for soliciting, $100 bond. You have an out-of-county hold for a felony. You do have a no bond hold, not for magistrate. What say you? We'll start with defense. Mr. Romero?
Same position, Judge, what I said. Her friend is gonna be posting her bond.
Okay.
And Judge, on our charge, is the possession of cocaine an out-of-county hold? Or is there there's another felony?
There's a possession of cocaine, capious, which is yours, and then an out-of-county hold.
Okay, so if she'd like to, Judge, she'd probably like to resolve this today so she can go into whatever county it is that has the hold on her. Ma'am, do you want to try to bond out on the municipal ordinance charge, or would you like to try to get time served on that?
I'd like to try to get time served.
Okay, and you understand that there's gonna be $78 in court costs that may affect your driver's license and or your credit if you don't pay that, and there'll be a $25 late fee if you don't pay that as well.
Okay.
All right, but you'd like to plead no contest to the municipal ordinance violation?
Yes.
Okay.
All right, ma'am, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
All right, is your name Irene Martinez, Martinez?
Yes, it is.
All right, you can put your hand down. It's my understanding you wish to give up your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
Yeah.
Don't tell me what it is, but does your mental illness affect your ability to understand what's going on here today?
No, it don't.
All right, you're satisfied with the advice you've received from your attorney, Mr. Shade, who's in the courtroom with me?
Yes, I am.
All right, do you feel, okay, how do you want to plead to loitering, soliciting, act, or prostitution?
Guilty.
Okay, you understand that if you plead guilty, the court's going to adjudicate your time, serve you, impose court costs of $78. You're going to have to take an HIV test
Okay.
within 30 days of your release.
Okay.
And provide the receipt, not the results,
Okay.
in 45 days to the clerk of the court. Do you understand that?
Understand?
All right, so do you feel that pleading guilty is in your best interest?
Yes.
All right, court's going to accept your plea on the MO case. Find that it's freely and voluntarily entered. Court has reviewed the court file and finds probable cause for the plea. Adjudication, time served, $78 in court costs, 6 months to pay. Partial payments accepted. HIV test within 30 days of release and receipt 45 days to the clerk of court. Is your mailing address 2215 Hope Street, Hollywood?
Yes.
All right, look for your court date on the possession. I'm gonna leave the bond at $1,000 per your request on count one, okay? Good luck, ma'am.
Okay. Thank you.
After that, Judge, I think I have on page 8, Eric Lopez de Victoria.
Mr. Lopez is approaching, he's here, ma'am.
Okay,
Judge, he has 8 different cases. And I know, like I've told you before, concerning the city of Hollywood, if they have more than 5, they have to be sent to the division. But of course, that's up to your honor. It's mostly, looks like lodging, open container, and selling something without a permit. And also the first
here's the
charge.
thing, he never shows up.
Exactly. So if we keep this, I mean, if we,
I was gone in New York. I went to New York City. They sent me to New York City, and I was gone for the last 3 years. They said if I left to New York City, they'll drop all cases.
These
And when
are
I got back-
2016
yeah, I
cases.
agree, Judge. So if the court would like, if the court can, I would like to.
This is what I'll do, I'll ROR you, or you can resolve them all today, up to you. Court would adjudicate time served in each different case. Court will do $78 in court costs, or you can come back to court. If you don't come back, then you're just gonna be rearrested again.
Time served, that's it.
Judge, Mr. Lopez, in speaking to him, in reference to count 4, that's the state offense of possession of cannabis, we'd ask you to consider a withholding judicial notice time served on count 4.
State?
That's fine.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
All right, your name is Eric Lopez D. Victoria. Devictoria?
Yes, ma'am.
All right, sorry about that. Put your hand down. Okay, Mr. D. Victoria, it's my understanding you wish to give up your right to a trial in all your cases?
Yes,
Yes? Anybody forcing you to
ma'am.
do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication now?
No, ma'am.
No? Okay. All right. All right, you're satisfied with the advice you've received from your attorney, Mr. Shate, who's in the courtroom with me?
Yes, ma'am.
And you're satisfied with the advice of Mr. Romero, your attorney, who's standing next to you in the jail?
Yes, ma'am.
All right, so how do you wish to plead to, let me read out the charges. I'm going to say guilty, not guilty, or no contest. No adult in play area, without consent, sell or display merchandise without a permit, no lodging on city-owned property, possession of cannabis under 20 grams, another selling or displaying merchant without a permit, another one of that too, lodging upon property without consent, and carrying an open, uncovered beverage in public. Guilty, not guilty, no contest.
No contest, ma'am.
All right, the court's going to accept your plea, find that it's freely and voluntarily entered. Court has reviewed the court file, finds probable cause for the plea. On each count, except for the possession of marijuana, the court is going to adjudicate and time serve. In each separate case, the court is going to impose $78 in the MO cases in court costs. In the MM case, the court has to impose the minimum court costs of $308. In the MO cases, Madam Clerk, I'm going to give 6 months to pay. Partial payments are accepted. On the misdemeanor, the 308, the court will give 6 months as well. And partial payments are accepted as well. You understand, sir, if you don't pay the court costs, they can suspend your driver's license, and there'll be a $25 late fee, and if you're caught driving while your license is suspended, obviously you'll be arrested, and it also can affect your credit. On the withhold of adjudication, hold on the MM case, court's gonna withhold adjudication and impose the court costs. Court does take judicial notice of the time served in the Broward County Jail on the MM case. Yes, sir?
How much time did you say I have to pay to all that?
6 months.
And that's only $308 or $308 in every case?
It's $308 in the possession of marijuana case. In the other case, that's 7 times 78.
7 times 78, all right.
Judge, considering his court costs on the municipal ordinance on the state offense, would give him 1 year to pay court costs?
Sure, I'll give him 1 year on the MM case. Okay, and the
Thank
court
you.
does take judicial notice of time served in the Broward County Jail on 18/2/22, it looks like 3. 2223 MM 48. All right, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Sir, good luck to you.
I believe that's it, Judge.
Are you sure?
The other ones looked like they were Fort Lauderdale.
Okay, if not, we'll give you a call. Thank you.
Yes, sir, take care.
Have a good day. All right, Torrance Walker.
Mr. Walker's here in Maine, Judge, and he is approaching.
Okay, Mr. Walker, you have trespassing, unoccupied structure or conveyance. Bond is set at $25. Court does find probable cause. Court is going to order no return to Any no return state? Oh, this is the car, okay.
No contact with Jameer Prescott.
Okay, sir, the court's gonna order no victim contact, direct or indirect, with the alleged victim with the initials JP. Do you understand what that means, or do you need me to, explain it again? I don't mind.
I understand.
All right, thank you very much. All right, what say you, defense?
Judge, in speaking to Mr. Walker, he wishes to ask the court if you would consider resolving this case today.
State?
Offer to be 5 days. He has a pending burglary of a conveyance and grand theft. Actually, you know what, Your Honor, I'm sorry. I'm withdrawing the offer. I don't have an offer at this time. My concern is that there's a
Possible
connection
armed
to armed
carjacking.
I'm actually gonna be requesting a bond increase to $1,000 based on, this involved a stolen vehicle. He's out on a release, burglary, conveyance, grand theft. Wasn't sure, that's why I said release.
What's the
No,
ad
I know,
charge?
I just didn't, carjacking. I don't know what the ad charge is. It's carjacking. He and his co-defendant.
All right, court's inclined to raise his bond. He has an ad charge of carjacking.
He's going to be at charge, Judge?
Carjacking.
So he's going to be brought back in the afternoon, or we're magistrating on him on that right now?
No, we're not doing that now, but they're gonna add it though, tomorrow or today.
Okay, hold on one moment, Judge.
Yes? Sure. Okay. While he's talking, come on up. Okay, Torrance Walker.
Yes, Judge.
Okay, sorry about that. We had to take care of something from yesterday. All right, so did you have an opportunity to speak to your client, Mr. Romero?
Yes, I have, Judge.
Okay. Go ahead. State's
Judge,
asking for $1,000 bond now.
Judge, like I said, initially our inclination was to ask the court to consider resolving. I believe the court said no. Therefore, at this time, I ask you to leave the standard bond in place. He was arrested on a trespass. That's what's before you now. I do realize he's out on a case. Judge, he's right now working for a company called Freight America. It's a moving company where he makes about $9.50 an hour. He lives in Lauderhill with his cousin. His cousin is helping him out, helping him live there rent-free. Basically, the person that posted his bond exhausted all their funds on the bond that they currently posted on him. So that's why he really has no sort of funds. So at this time, we don't keep the $25 bond in place.
All right, the court is going to increase the bond to $1,000 based on everything I've heard today, based on the totality of the circumstances. And noting also that this car that Mr. Walker was in was a vehicle taken during an armed carjacking out of Fort Lauderdale, and he's going to be charged with an armed carjacking. $1,000 bond, thank you. Jermaine Ramsey.
North Broward Medical Research, Your Honor.
All right. Is the City of Fort Lauderdale attorney here? No, okay. Nakia Gertman?
North Broward.
Yes, ma'am.
Okay, good morning, sir. How are you?
Good morning. How are you?
Fine, thank you, sir. You have misuse, this is a public order crime, misuse of the 911 or the E911 system. Court does find probable cause, bond set at $100. Your mailing address, sir, 450 Southeast 2nd Street, number 2, Pompano Beach.
Yes, ma'am.
All right, what say you, defense?
Your,
You want to say something?
I have something to say, but you said defense, so I'm
No, that's okay. I didn't know you were going to say something. Go ahead.
This court released this defendant to standard pretrial supervision on August 9th. He has not shown up.
Okay.
I understand he was arrested yesterday, but he had enough time to get to pretrial and he did not. He was released on case number 187607, MM10A, 1 count of trespass and 1 count of disorderly conduct. Based on the finding of probable cause, we're going to ask that his pretrial status be revoked.
And Your Honor, just to advise the court,
Your Honor,
the allegation.
Hold on, sir.
Don't say anything just yet,
Hold
sir.
on, everybody, just 1 minute. Sir, you have an attorney representing you, Mr. Reedy, in the courtroom, who I believe you spoke to. Did you speak to him, Mr. Reedy? Yes, sir. Okay, so you spoke to him. Just hold on. We take turns here. Let the state say what they have to say. Your attorney will respond, and potentially you'll say something. So, go ahead, state.
Your Honor, I just wanted to advise the court, the case that he's out on, the allegations in that case is that he was trying to fight people in the triage unit that were there to get treatment. And now this involves the same hospital.
Okay.
and Your Honor, I have papers that I
Don't say
was in
anything
the
just
hospital.
yet, Mr. Gertman. Judge, I did speak with Mr. Gertman earlier today. We talked about the Henderson Reception Center. Mr. Gertman has a number of issues that need to be resolved, as I think is pretty obvious from his alleged behavior recently. He does have,
I think
he's in
maybe
need of some
Lerner Wren is in
services.
order.
I'm sorry?
What about Judge Wren? I mean, he's fighting people in triage in the hospital.
I
doesn't
wouldn't
show up
object to
for
that, but I
trial.
think, he is a gentleman in need of some services, there's no doubt.
Okay, I agree.
And just so the court knows, the pending case
Your Honor.
has been assigned to judge.
Can you hear the lady talking?
No,
Did you
ma'am,
hear?
I-
Okay, if you could repeat that, Ms. Patrice, and put your mic on, please.
The case that is pending is assigned to Judge Lerner Wren.
Which one?
It's
The
empty though.
Right, understand,
Yeah.
it's already.
Excuse me, I have paperwork in my property that I was in the hospital. That's why I couldn't show up at pretrial. That's what I was trying to say. I have proof that I was in the hospital. That's why I couldn't show up for pretrial when I got released.
The problem, Mr. Gertman, is that you also got rearrested while you were on pretrial.
Mount Saint now, I was in Irie and they transported me to Miami Beach. I was Baker acted over there from Mount Saint now. That's why I couldn't go to pretrial. That's why I couldn't show up for pretrial release. And when I got out, I was also still feeling kind of. I was trying to get treatment at the Memorial Regional, but for some reason they was not trying to help me out. I have an appointment with Henderson Clinic, and I need an earlier appointment. August 27th.
This is what the court's gonna do, and have 18-7607 MM10A. Court's gonna revoke his pretrial. Court is gonna do a $25 bond on one, $25 bond on two, and for this case, we're gonna transfer this to Judge Wren as well. Court's gonna do a $98 bond. Thank you very much, sir. Good luck to you. You'll see Judge Wren. If you could maybe call up Judge Wren and,
Both, okay.
yeah, both cases.
Keep in mind that Henderson Reception Center, Mr. Gertman, when you get in front of Judge Wren, that might be an option available to you.
Oh, Miss Patrice, I apologize. I always do that to you.
I was just looking, I wasn't sure if it was mine.
Yes, it is yours. Thank you.
All right.
Okay, Vivian Pringle, please.
He's approaching, he's here at Main.
Okay, good morning, Mr. Pringle. You have an ad charge.
Good morning, Your Honor.
Good morning. You have ad charge 5, grand theft in the third degree, $1,000 bond. Court does find probable cause. You do have a court date coming up with your judge, Judge Martin Fine, on August 17th, which is in 3 days at 8:45 a.m. What say you, defense?
Judge, my understanding, I believe he's being held on a no bond hold on another matter. So, having said that, Judge, at this time, we have nothing to add in reference to this count.
All right, then the court will set the bond at $999. Defendant has no bond hold. Okay, sir, you'll see Judge Fine, 8:45 on Friday. Good luck to you.
Your Honor. Thank you, Judge. Judge, when you have a moment, if you could, you're done. Judge, could you address the gentleman out of turn? My understanding is, I believe, he has to go to, medical to get
That's
medication.
fine, just give me who he is.
His name is Andra Rett. He is on page 18 of your docket.
WR or RH?
No, RH, correct. RHETT.
No problem. Okay, Andre Lavelle Rett,
He's approaching, Judge.
no
He
problem.
has to just be seen by medical. That's the only reason why we're calling it.
That's fine, not a problem. What page?
On page 18 of your docket.
Page 18. Okay, good morning. Are you Andra Lavelle Rett, sir?
Yes, ma'am.
All right, sir, you have grand theft between $300 and $5,000, $1,000 bond. Count 2 is a probation violation or community control. You have a no bond hold. You are going before your division judge on division, let's see, FE is Judge Edward Merrigan on August 15th at 8:45 a.m.
Thank you, Judge.
Court's going to set $999 on count 1. Thank you, sir. Good luck to you.
Thank you.
Paul David Williams, please.
Mr. Williams, come on up, please.
Yes, ma'am.
All right, Mr. Williams, good morning, sir. You have petty theft, second degree, third subsequent offense, $750 bond. You do have a probation violation where you're being held no bond. You are going before Judge Elizabeth Shear on August 20th, which is this coming Monday at 8:45 a.m. Court does find probable cause. Court will set bond on count 3. It's counts 3 and 4. Count 3 at $749. Next Monday, Judge Shear. Thank you, sir. Good luck to you. Nicholas Andrew Hildegal. Hildigo?
He's approaching, Judge. He's here at me.
Okay,
Morning, Your
good
Honor.
morning, sir. How are you today?
Good, how are you?
Fine, thank you. You have 3 counts, each the same: burglary, unoccupied conveyance, unarmed. The court does find probable cause. What say you, State?
One moment, Judge.
I would advise the court, I believe his co-defendant is the next case on the docket, Mr. Romero.
Okay,
No relation, I'm sure. Mr. Romero's family is here.
okay. Okay, the court is, while the state's looking at the case, court is gonna order, sir, no return to the Coral Springs Auto Mall located at 9300 West Atlantic Boulevard, Coral Springs, Florida. If you go back there, sir, you'll be arrested. Do you understand? Yes? Okay,
Your Honor, I would be requesting $2,000 on each count.
okay, what's his prior history, State?
I don't see any.
Okay, sir, is your mailing address 7612 Northwest 73rd Terrace, Tamarack, Florida?
That's correct.
Okay. Okay, what say you, defense?
Judge, what was the state's response as far as this prior criminal record?
$2,000, nothing.
No. Judge, my understanding he's 18 years old. He's a graduate of Terravella High School class of 2017. Right now, he just obtained employment in the construction. He's been there about 3 weeks. He works Monday through Friday. He gets paid about $100 per day. He lives in Tamarack with his mother. His mother works at Wells Fargo in customer service. They've been living at the same residence for the past 5 years. His mom pays $13.50 a month in rent. His portion is the $350. Judge, I'd ask you, considering this is his first offense, Judge. Considering he has a clean record, I'd ask you consider a $500 bond on each count, Judge.
How about just $1,500 bond on count 1?
That would be fine, Judge.
Okay. All right, so he has someone that's gonna bond him out. Does he need a phone order or anything?
He does need a phone order. Yes, he's going to be contacting his mother, and that's who he's going to call to post bond.
Okay, so $1,500 bond on count 1, ROR on 2 and 3. No return to the Coral Springs Auto Mall. Thank you, sir. Good luck to you. Next one is Junior Romero.
Mr. Romero has family present here this morning.
Okay. Okay, if his family would like to come up, or somebody, you don't have to, but you can come up so he can see you. Just step up to the podium, to the microphone. Okay, Junior X Romero, is that your name, sir?
Yes, ma'am.
All right, we have 2 persons here. Can you each state your first and last name, spell your last name for the record, and tell me your relationship to Mr. Romero, please?
My name is Ilario Mazarregos. I'm his cousin.
How do you spell your last name?
Mazariequos.
Thank you.
My name is Dori Romero.
Can you get a little closer to the microphone? I'm sorry.
Dori Romero.
Spell your last name? Romero, R-O-M-E-R-O?
Yes.
All right, thank you very much. Are you here today just for support? Or is there something you'd like to tell the court, or do you want to wait till everybody's finished talking and then we can speak to you? Step forward, I can't hear you, I'm sorry.
No, we have nothing to say. Just
Okay, so you're just here for support. All right, well, we'll see if you have something to say after everybody goes. All right, so, Mr. Romero, you're charged with the same thing as Mr. Hidalgo, which is burglary, unoccupied conveyance, unarmed. We need to talk about bond. Court does find probable cause. Court's gonna order, sir, same thing. No return to the Coral Springs Auto Mall, 9300 West Atlantic Boulevard, Coral Springs, Florida. What say you, state?
Requesting $2,000 on each count, Judge.
Okay, what's his priors?
No priors, Judge.
No priors, 2,000 each. What say you, Mr. Romero?
Judge, this is his first arrest or contact with the criminal justice system. He's 22 years old. He's a United States citizen. He's a registered voter here in Broward County. He has a part-time job. He works at Foot Action, been there for about a year and a half.
What are you
making $9
asking
an hour.
for?
Judge, I'm going to be asking on him an outright ROR. If not, then I'd ask you to set a $1,500 bond on count 1 and ROR counts 2 and 3.
1,500 on 1, ROR on 2 and 3. Let me just confirm his address, 9166 West Atlantic Boulevard, number 1621, Coral Springs.
Yes.
All right, sir, look for your court notice in the mail. Who's going to bond him out? Does he need a phone order?
His
Family's
is
here,
gonna-
Judge. I've already spoken
Okay.
to them about it, so I'm gonna have another conversation with them right now.
And he appreciates his family being here for support, Judge.
Thank you. Good luck, folks, okay? Thank you. Next one is Johnny Lee Sawyer, please.
Mr. Sawyer is approaching, Judge.
Okay, Mr. Sawyer, you have driving while license is suspended, third or subsequent offense, $750 bond. Count 2 is leaving the scene of a crash involving damage to property. That's basically an ROR, there's no charge attached to that. And count 3, attaching a registration license plate not assigned, no bond attached to that. The court does find probable cause, $750 bond. Your mailing address, sir, 1461 Southwest First Terrace, Apartment C, Pompano Beach.
Yes.
Okay, what say you, defense?
Judge, we're going to be asking for Your Honor to consider releasing him on pretrial release. He's 32, been here his whole entire life. He does work. He supports his family. He works for a roofing company. Been there 6 months now, making $370 a week. He lives in Pompano Beach at the address you mentioned, and his rent there per month is $800. His girlfriend, who resides there, just recently got out of the hospital, some sort of But having said that, that's right now preventing her from working. That's why he's supporting his household. And on top of that, he does have children. He pays child support. They take the money directly out of his check, and he pays $387 per month. So, Judge, right now financially he has no one to really post his bond. We're going to be asking for pretrial release.
I have no objection to pretrial.
What's his prior history?
One moment, Judge. Delivery of cocaine, 2011 with a violation of probation.
Standard pretrial, thank you. Report within 24 hours, sir. You're gonna have to report once a month in person and call in 2 times a week, okay? Thank you.
Okay, as soon as you get released, there's the map. You walk across the street. That's where pretrial. If you don't show up, there's a warrant at your free rent, so you better be there, okay? Good luck, sir.
Okay, Andrew Edward Kirkland, please.
Mr. Kirkland is with us.
Okay, good morning, Mr. Kirkland. You have possession of cocaine and possession of drug paraphernalia, $1,000 bond, sir, on count 1. Court does find probable cause. What say you, defense?
Judge, I'm going to ask for pretrial, see if state has an objection.
One moment.
The ones that say NC? Let me see. Okay, the 750 is ROR, and the last 2 are NCs, okay? Thank you. Hello, what's going on? Come on, have a seat here for a second. I don't know if we have any, we didn't send anybody to the receiving center today, did we? No.
Not here, Main Judge.
Oh, I'm sorry.
I meant today, no. Okay, go ahead.
I would be objecting to pretrial, Judge.
Okay, tell me why.
Oh, I'm sorry.
Okay, 4 prior failures to appear. He's got a warrant out of Dade County for $7,500 right now for failing to appear in court. He got out of state prison in 2015 for battery against a law enforcement officer, where he was sentenced to 38-month state prison as a habitual offender. He also had 2 separate possessions of cocaine in 2012, where he violated probation and was sentenced to 38-month state prison. Possession of cocaine, alprazolam, 09, just over 14.5 months state prison.
Judge, he's 49 years old. He's been here over 20 years. He has a part-time job in landscaping. He's trying to make that full-time, but all he has right now are part-time hours. He lives in Pompano Beach. Right now, his portion, they let him pay $50 a week, and that's where he can reside. He's been there for 1 month. He just got that place. There's nobody that's going to be able to post that bond right now. This is a drug offense. Unfortunately, we're still having that same situation with the lab, so he'll eventually be released ROR. So I'm asking, rather than him waiting on the third day to be released, I'm asking him released
mean
under
33rd
supervision at this
day?
time. Yes.
What's his mailing address?
41, 25th Court. You're going to have to say it nice and loud so the judge can hear you, okay? Nice and slow, because she's going to write it down. 241, 25th Court.
241, is it northwest, southwest?
Northeast.
241, pull this up, northeast.
25th Court.
And where is that located? What town?
Pompano Beach.
Oh, that's where you reside in the camper, obviously? Okay. So, this is what the court's gonna do. Sir, I'm gonna give you an opportunity on standard pretrial supervision. But this is how this is gonna work. If you don't report within 24 hours, or you get a new arrest, you're gonna get violated. And then you could potentially be on a no bond hold, so it's up to you. So show up in 24 hours of your release. If you get out today before 3 p.m., go over there, it's right by the jail. And if not, you have to go by tomorrow by 12 noon.
Yes, ma'am.
You understand? You have to call in twice a week. If you get a new arrest, that'll violate your pretrial. And the other thing is call in twice a week, report once a month, and report by tomorrow, okay? Good luck to you, sir.
Yes, ma'am. This the address?
Anthony Davis?
Oh, sure. Don't let it down. All right, take care, sir.
Mr. Davis, you have criminal attempt to solicit, conspire, third degree felony burglary, $3,500 bond. Court does find probable cause. What say you, defense?
Judge, he's not going to be able to afford the $3,500 bond. He's 25 years old, been here his whole entire life. Right now, he's looking for work. He lives in Fort Lauderdale with his sister. His sister's helping him out. His sister works for the school. She's a school security guard. And right now, since she pays all the bills, she's a single mom. She supports her kids. Kids are going back to school. She's already spent all the money with back to school supplies. So she's not in a position to post a monetary bond. So, Judge, we're going to be asking for pretrial release.
What's his priors?
Well, it looks like he was arrested January of this year for operating without a valid DL. He was placed on pretrial. Then he failed to appear in court and was arrested in late May for failing to appear in court and pled the case out. 2015, possession of PVP. 2013, resisting without violence.
He did give a statement to the police, Judge, which, without that statement, they might not have had a case at all. It could also be viewed as an attempted burglary conveyance.
Well, here's the thing, I mean, this is a burglary attempted, and he violates pretrial.
I know, that's a
So what can he
separate issue,
afford in
not-
bond?
Judge, maybe his sister might have some leftover money from, hopefully, she bought school supplies on sale. So maybe she can come up with a premium $100.
Okay, $1,000 bond. Instead of the $3,500, is his mailing address 889 Riverside Drive, number 114, Fort Lauderdale?
Correct.
Not 114, no.
It's 101, Judge, 101.
Hold on. It's 889, what's 101, the apartment or the house?
Yes, the apartment.
clerk to update address. All right, let me read it back to you, just so I'm sure, sir. 889 Riverside Drive, apartment 101, Fort Lauderdale, right?
Yes.
Okay, good luck to you, sir. And no return, sir, to 1525 Southeast 6th Street in Deerfield Beach. Do you understand, sir? If you go back to that area, I want you to maintain 1 mile from that address. Do you understand?
Yes.
All right, thank you, sir. Good luck to you.
Good luck, sir.
Randolph Sherlock. Hello, Mr. Sherlock. You have aggravated battery, caused bodily harm or disability. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim with the initials LTW. Do you need me to explain what that means, sir? I don't mind.
Yes, ma'am.
All right, that means no contact in person, no calling, texting, writing, no communication or contact whatsoever, and that includes social media, and no contact through third parties. That includes whether you're in jail or not. That means don't send messages through one person to the alleged victim with the initials LTW. All right, state what say, court does find probable cause. State what say you as to count 1.
Your Honor, I'm going to be requesting a $50,000 bond, pretrial release of the GPS monitor, based on the level of violence that he allegedly stabbed the victim with a butcher knife.
Yes, I think the key word there is allegedly. From reading this probable cause affidavit, it appears as though this is an argument over a drug deal between Mr. Bryce and the alleged victim in the case. There does not appear to be any other evidence other than 2 things here. One is the victim's statement saying that it was some guy named Dredd who stabbed him. Nowhere in the report does it indicate that Mr. Bryce is Dredd. And secondly, there is a reference to a statement that the defendant confessed to the stabbing, but we don't have any further details about that statement, which makes me very suspicious about it, because it's one thing to say, yeah, I stabbed him, but he was coming at me with a baseball bat or a club or whatever, and just to have a bare-bones statement here that the defendant confessed to the stabbing. We don't have the supplemental report, we don't have a copy of the confession, we don't have a transcript of this alleged confession, and I think that based on the weakness of this probable cause affidavit, a bond as high as what the state is requesting is unreasonable.
Your Honor, there is not a weakness to this probable cause affidavit. However, Mr. Reedy wants to try to spin it. There's video surveillance, the knife was recovered, and Mr. Bryce is personally known to the victim.
Yes, but Mr. Bryce's name is never mentioned. He's only referred to as Dredd. There's no indication that he is Dredd. There's no photo lineup being conducted. There's no other type of form of identification made in this very weak probable cause affidavit. Again, it's over a drug deal.
It says the defendant did commit an aggravated battery, and then it says within the report, Dredd. So, I mean, common sense would dictate that Dredd is Mr. Bryce, but go ahead. I'm just saying that portion of your
I think
argument.
the court's making an assumption there, and that's not what we're here to do. We're not here to assume. We're here to see if the elements of the crime are contained within the 4 corners of the probable cause affidavit. And I think that the court can find probable cause, but I would ask the court to be very, very suspicious of the content here. When you have a very poor ID, and a knife was recovered, there's no tying this knife to Mr. Bryce. There's no indication that fingerprints were lifted off the knife. There's no indication that there was any blood on the knife. There's no indication that this is the knife that was used to stab the alleged victim. And again, we just have this bare statement the defendant confessed to the stabbing. And I'm very suspicious when a detective writes in a report something so incomplete about the most important piece of evidence in the case, which would be Mr. Bryce's confession. I think what we would expect to see, if this was really what the detective purports it to be, would be Mr. Bryce confessed to the stabbing and admitted this, that, and the other thing, and this is why it happened, and went into great detail about what Mr. Bryce allegedly said. Apparently, we do not have that before the court, and I think that makes this a weak probable cause affidavit, and a bond of $50,000 is unreasonable under these circumstances.
Your Honor, this is a probable cause hearing. It is not trial. The officer's writing this report for the court to determine probable cause. And Mr. Reedy can try to put any definition he wants onto the word confess, but there is an accepted definition of confession, and it states that he confessed to the stabbing.
And it says nothing else about what he might have said. And I'm not saying that this is a probable cause argument. I understand why we're here. But this is certainly factors that this court can take into consideration when determining an appropriate bond for Mr. Bryce.
And I would note, the victim did in fact suffer a stabbing injury and stated the defendant is personally known to him.
Okay, what say you, Mr. Romero?
Judge, $50,000 is going to be something out of reach for Mr. Bryce. He's 53 years old. He's working. He works at a restaurant called Mama Meals. He's been there for 8 months. He's a dishwasher. He makes minimum wage, about $8.50 per hour. So what he does is, Judge, he has no formal residence. Whenever he manages to save up enough, he'll live at a hotel in Hollywood. If he doesn't have funds for the night, unfortunately, he'll be homeless. However, he did advise me he does have a mailing address as far as where he can get mail. Right now, Judge, my understanding is he does have prior contact with the criminal justice system, but it's quite old. He advised me it's over 10 years old. Judge, I'd ask you also to sign an order allowing us to photograph the injuries that Mr. Bryce sustained. Judge, considering his financial circumstances, considering the mitigating circumstances that my colleague offered, I'd ask you to impose a monetary bond of $1,000.
Okay. I understand both sides' arguments, but this is a serious incident. Says here, the victim was actively bleeding and had several pieces of gauze and blue painter's tape partially covering the wound. The victim had difficulty breathing and speaking, but advised that a black male known to him as Dredd stabbed him with a kitchen knife after a scuffle over an attempted drug deal. So the court's going to order no victim contact, direct or indirect. Court is going to do GPS level 2. Court is going to have the defendant maintain 1 mile from LTW. No possession of any firearms, ammunition, or weapons. Court is going to set a $15,000 bond on count 1. Thank you, sir. Good luck to you. Sean, Michael, Rich, and then we're going to take a break.
Yes, Judge. Rich is approaching. He's here at me.
Okay, Mr. Rich.
How you doing, man?
Good, fine, thank you. You have battery on an officer, firefighter, EMT, and you have resisting an officer with violence. You have resisting an officer without violence, $100 bond, and you have count 4, trespassing, unoccupied structure or conveyance, $25 bond. Court does find probable cause. Excuse me, what say you state on counts 1 and 2?
Your Honor, I'm going to be requesting a $10,000 bond on count 1, a $1,000 bond on count 2. Based on the allegations in this case, and Mr. Rich does have violence in his past. He pled out a felony to a misdemeanor battery just 4 days before this incident. He's pled out trespasses May 20 of this year, May 29th, May 3rd, April 24th, April 11th. Resisting without violence last year. 2017, felony battery, domestic violence by strangulation and false imprisonment. He violated his probation. Grand theft auto 2016. Resisting without violence and battery 2016. Trespass 2014, possession of cocaine 2014, resisting without violence 2014, resisting without violence 2014. He had end of record, Judge.
Okay, I'm sorry, what's the amounts again, state on 1 and 2?
10 on 1, 1 on 2.
Okay, go ahead, Mr. Romero, or Mr. Reedy, I'm sorry.
Mr. Romero can go to.
Judge, I'm speaking to Mr. Rich, $11,000, simply something he's not gonna be able to afford. He's 22 years old, he's been here his whole entire life. Sorry that, Judge, he's 27 years old, he's been here his whole entire life. Some of the prior lender was reading off, Mr. Rich did advise me the word dropped. Having said that, Judge, he works at a labor pool, so whenever he can get work, he gets paid by the day. As you know, Judge, labor pool fluctuates depending on the job, anywhere from $60 to $80 per day. At this time, he does live with his mother. His mother is a school guard. She's the one who gets the monetary amount on the rent and the apartment that he lives at, Judge, which is located in Pompano Beach. My understanding is the location where he was basically confronted by the police officers is next door to the laundromat. He was there washing his clothes, and that's when law enforcement, when I believe there's a convenience store right next to it, approached him. Thankfully, Mr. Rich did tell me that he had several friends at that location that actually witnessed the arrest and actually took out their cell phones and captured the incident. And it's going, from what he informed me, they advised him it's going viral on Facebook, where allegedly it shows the police officer's body slamming Mr. Rich. He's adamant that he didn't hit any law enforcement officers, but I told him that's going to be for a later date. And having said all that, Judge, what I'm going to be asking for on count 1 is a $1,000 bond, and on count 2, a $500 bond. I believe under the circumstances that would be reasonable, Judge.
And Your Honor, I want to advise the court, none of the cases I brought up were dismissed. Since it's been brought up, the charges that were dismissed, and it was on competency grounds, an escape in 2016, resisting with violence and battery 2015, robbery with a firearm or deadly weapon 2012, grand theft auto and battery 2011, felony battery, domestic violence by strangulation in 09, carrying concealed firearm in 09. There were other cases, but those were either the ones that involved felony and then these felony violence, and then the escape.
Okay, 3,500 on 1, 500 on 2, ROR on 3 and 4. Court does find probable cause, thank you. Alberto Gale?
Mr. Alberto Gale is, we got word, I guess confinement status removed him from the docket? Yeah.
We asked him for jail to be reset for PM. There was an additional charge.
Okay, no problem. Okay, so Madam Clerk, if you could reset for 1 PM. All right, we're going to take a break for just 5 minutes. All right. I understand, and as, what am I gonna do? I mean, I can't, I have to look into it now. So, well, we hold her overnight at her request, but in any event, but I understand what you're saying. She should have been released at 9 a.m.
Right. That's what we kind of promised.
And then there's another person they didn't release as well. We'll talk about it after this. Christopher Falzoni.
He's here, President, main judge, and we'd be waiving formal reading of the charge.
All right. What did you say?
One of the MOs, she was scheduled before Judge Lerner Wren at 9 a.m. this morning.
Which one?
18540 MO 48.
All right, so, sir, we have to speak to, the court does find probable cause. State, what say you with regard to bond and any special conditions, please?
Your Honor, I'd be requesting a $50,000 bond. Pretrial release, GPS level 2, no victim contact, no contact with minors, and noting the age of the alleged victim in this case, 10 years old.
Okay, can I have the alleged victim's initials, please?
VS.
Okay, sir, you are to have no contact, direct or indirect, with the alleged victim with the initials VS. Go ahead, defense.
Judge, right now, from what Mr. Valzone advised, he's not gonna be able to afford to pay that $50,000 bond. We're gonna be asking for $10,000 bond. We're okay with Mr. Falzone being supervised on standard pretrial release. My understanding his only prior offense is a misdemeanor cannabis offense that happened several years ago. Having said that, he's 35 years old. He's been here almost the majority of his life, Judge. He lives in Davie by himself. The apartment he's been renting at for several years, his monthly rent is about $900 per month. He owns one vehicle. It's a Nissan Versa. It's a 2015 that he bought used at CarMax, and what he's paying about $385 per month, and he has 4 more years left on paying for that vehicle. He has family that live in our community. Specifically, he's going to be reaching out to his father to help post his monetary bond. Basically, from what Mr. Falzone advised me, his father has limited funds. So, Judge, considering his strong ties to community, his lack of basically significant contact with the criminal justice system, that's why we would be asking you for a $10,000 bond on this allegation with pretrial release, Judge.
Anything further, State?
Your Honor, I would just also, as far as the strength of the evidence, I would note his post-Miranda admission.
His what?
Post-Miranda admission.
All right, no victim contact, direct or indirect, with the alleged victim VS, and I want you to maintain 1 mile at all times. GPS level 2, $25,000 bond on 1.
Your Honor, did the court order anything regarding minors?
No contact, sir, with any minors. Thank you. Good luck to you. By the way, getting back to Rackle, you took it away, Michelle.
I did, I'm sorry.
It said some JA called back the case and held her. I don't know why someone would do that. Because it was pending in Judge Francois' division. call Judge Francois' office in Hollywood and ask if they called about that case. Does anybody know why?
No what, Judge?
It's something else with someone from yesterday.
Okay, no problem, Judge.
Jerome Vaughn?
He's here with us at Maine.
Okay, Mr. Vaughn, you have burglary, unoccupied structure, unarmed. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim, sir, with the initials RT. Do you understand what that means, sir, or do you need me to explain it to you?
Yes, ma'am, I understand.
Okay. What say you, State?
Your Honor, requesting a $5,000 bond. His criminal history, disorderly intoxication, July of this year. 2017 battery, he violated probation. 2015 grand theft auto with a violation of probation. 2015 possession of PVP with a violation of probation. 2014 sale or delivery of cannabis at or near a school or park or convenience business. Possession of cannabis with intent to sell. 17 and a half months Florida State Prison. 2012 battery. 2012 grand theft auto resisting without violence with a violation of probation. 17 and a half months Florida State Prison. 08 resisting without violence.
Defense?
Judge, in speaking to Mr. Vaughn, from what he advised me, he's put, he's looking forward to his day in court. These are allegations. Mr. Vaughn did advise me that he's 28 years old. He's been here his whole entire life. At this time, he's looking for more stable employment, but when he works in landscaping, Judge, to try and help out his mom. He lives in Margate with his mother. His mother works at the local school cafeteria, and right now his mom is basically supporting the household, supports him and his sister. Judge, financially, from what Mr. Vaughn advised me, his family cannot afford to post a monetary bond, so he'd be asking Your Honor to consider releasing him on standard pretrial on this third-degree felony.
Well, he tried to go into someone's business. So this is what the court's gonna do. I'll put him on no bond required, GPS level 2, no return, sir, to 2755 Southwest 1st Street, Fort Lauderdale, Florida. You're gonna live at 6557 Northwest 1st Street, First Court, Margate, Florida.
Yes, okay.
Thank you. Good luck to you. Terrell Jenkins, please. So Judge Bren said it didn't, can you call Judge Bren's office back and see if they requested for her to come up and why they were alerted to her? Because the case is Judge Francois. Terrell Jenkins?
He's here,
Mr. Jenkins, you have possession of burglary tools with intent to use, burglary, unoccupied structure, unarmed, bond set at $1,000 on one. On count 2, we need to talk about bond. State, what say you?
Your Honor, I'll be requesting $5,000 bond on count 2. No return to the business. It's criminal history. Resisting without violence and trespass, 2015.
Okay.
Fleeing and eluding law enforcement, resisting with violence, DWLS, 2013. Violation of probation, 23 and a half months, Florida State Prison. 2012, resisting without violence. 2010, resisting without violence. 09, possession of cocaine with a violation of probation. 07, possession of cocaine with violation of probation. 05, possession of cocaine. 02, resisting without violence. 01, delivery of cocaine with a violation of probation. 01, battery on a law enforcement officer with a violation of probation.
Okay. The victim contact, direct or indirect with the alleged victim with the initials RT, and no return, sir, back to 2755 Southwest First Street in Fort Lauderdale. Do you understand, sir? Yes?
Yes, ma'am.
Okay. Go ahead, Mr.
Judge,
Romero.
we're gonna be asking for pretrial release. He's 36 years old, been
I
here
can
his whole
tell
entire
you,
life.
I'm not gonna give him pretrial release with that criminal history.
What was the
So,
last that, the state said was his prior contact?
okay,
Mr. Jenkins advised me the last significant contact was in 2015, over 3 years. So that's why I thought, since his last significant contact was 3 years ago, considering these are third-degree felonies, I would think it would be reasonable to ask for pretrial. Judge, like I said, he's 36 years old. He's working in landscaping. He gets $100 a day when he gets employed. He lives with his sister in Fort Lauderdale. Right now, their monthly rent is $900. She's a school custodian. And if Your Honor were to impose a monetary bond, that's the only person he could reach out to maybe potentially post his bond. But he does not think she has any sort of funds because she's basically supporting and paying the whole rent. So that's why we'd be asking for pretrial release on his behalf. But if Your Honor were not inclined to do that, then I would be asking for, leave the standard bond in place on count 1 and ROR count 2, or 500 on 1, 500 on 2.
A couple things. One, Your Honor, Mr. Romero is right. His last arrest was 2015. However, he went into state prison on October 1st, 2015, and was released from state prison April 27, 2017. So yeah, you can't really get arrested while you're in state prison. Additionally, his request for a $500 bond, he's asking for a $1,000 bond on the burglary tools and a $500 bond on the actual burglary?
No, I said 500 on 1, 500 on 2, or ROR count 2 and 1,000, so a total of 1,000.
1716 Northwest 13th Court.
Is that the address?
Yes, but where I work is where I live. It's 80 Northwest 29th Avenue on First.
What is that?
That is it. I do home improvement and landscaping, so I watch over these people's property while they go until it gets sold.
That's even less comforting considering these allegations.
Does he want me to change his address?
Judge, what he's explaining to me is he does landscaping, and I guess the people that employ him is that property. When they go out of town or something like that, he stays there and looks over their place.
Sometimes.
But
I don't have a problem with that. I'm putting him on a GPS. What's his address?
what's your address?
1716 Northwest 13th Court.
1716 Northwest 13th Court, sir?
Yes, ma'am.
All right, thank you very much. I'm going to put you on GPS level 2, no bond required. Thank you. No victim contact, and sir, no return to 2755 Southwest First Street. And you are to maintain 2,000 feet. Thank you. If there's an issue with the feet, Miss Patrice, get back to me, okay? We can always amend it with where he lives. Brandon Simmons.
He's here.
Hello, Mr. Simmons. You have a grand theft auto, $1,000 bond. Court does find probable cause.
Judge, he's not going to be able to afford the $1,000 bond. We're going to be asking for pre-trial. He's 33 years old, been here his whole entire life. Works in construction. He's the actual person that puts the stucco on the cement walls. He's just got that job 2 weeks ago, making about $10 an hour. Living with his mom in Fort Lauderdale. He's been living there for about 2 months now. His family doesn't even know he's here. Unfortunately, when he was arrested, he didn't have his phone on him. He doesn't have any numbers memorized. So there's nobody that he can contact to help post his bond. And even if he could, from what he advised me, he doesn't think they can afford anything. And that's why we're asking for the court to consider pretrial release.
State would object, Your Honor. In addition to being the person that puts the stucco up, He's the driver in the Grand Theft Auto where he's being charged, my understanding, for armed carjacking. He additionally, you had his co-defendant earlier on the trespass charge. Additionally, his criminal history, 2017, possession of PVP, he pled that out March of this year. Possession of cannabis with intent to sell or deliver at or near a school, park, or convenience store business, 2013. He violated probation, was sentenced to 17 and a half months state prison. Possession of cocaine twice in 07 with a VOP. Burglary of a dwelling in 03 with a VOP, 36 and a half months Florida State Prison.
Okay, defense.
Just relying on what we said earlier, Judge.
All right, so he has an armed carjacking charge coming.
That's my understanding. That's BSS
that correct?
looking in on that now.
999, count one. Isaiah Underwood.
Mr. Underwood is here.
Okay, Mr. Underwood, you have failure to register as a career offender. Court does find probable cause. What say you, State?
Your Honor, I'm going to be requesting $7,500 bond, pretrial release with a GPS monitor. He had the same offense in 2017. He pled out in front of Judge Fine February 19th of this year. 07, when did he get it? 07, burglary of a structure and theft, 10 years state prison as a habitual offender. 03, burglary, and he was released 2015. 03, burglary of a structure, VOP, 10 years state prison as a habitual offender. Another burg structure in 03, same sentence. 98, burglary conveyance, 14 months state prison as a habitual offender. 97, burglary of a occupied structure, a year and a day state prison. 2 more burglary structures in 97, year and a day each. Assault, 97, goes on from there.
You're asking for 7,500, you said?
And a GPS, yes, Judge.
Okay. Defense?
Judge, he's basically financially indigent. He's 55 years old. He works part-time in landscaping where he gets anywhere from what he advised me, $30 to $60 a day. He has no money in the bank. He owns no sort of property. He lives in Deerfield Beach. He's renting a room in a house, and he pays about $120 a week for that location. Judge, he said there's no one out there that can post any sort of bond, so I'd ask you to take that into consideration in determining reasonable release conditions.
Court's going to set bond at $3,500. GPS open schedule. Thank you. Kite Drain Lewis, please. Hello. Kite Drain Lewis, please.
You're at main, Judge.
Okay, Mr. Lewis, you have an aggravated assault with a deadly weapon without intent to kill. Court does find probable cause. What say you, State?
Your Honor, I'm going to be requesting a $10,000 bond. No victim contact, no return to the incident location. Mr. Lewis's history, he had a theft that he resolved 2 weeks ago. 2017, aggravated assault with a deadly weapon. 2013, sale delivery of counterfeit controlled substance.
Judge, from what Mr. Lewis advised me, right now he's financially indigent. He is homeless. He does have a mailing address. It would be of his grandmother who resides in Fort Lauderdale. When he can, he does roofing work. It's nothing stable, Judge. From what he advised me, there's no one that's going to be able to post anything for him.
He owns no sort of property, has no money in the bank, no stocks, no bonds, no tangible assets. Judge, for all intents and purposes, he's financially indigent. We'd ask you to take that into consideration in determining reasonable release conditions.
Sorry, what's the amount you're asking for?
Judge, he can't afford anything.
And I'd point out, Judge, also that most of the evidence here appears to be from Mr. Lewis's own alleged statements. He said at one point he did not have a knife, it was only a switchblade. So there's lack of probable cause as to whether or not this is actually even a deadly weapon. The review of the video states he approached the victim with an object in his hand in an aggressive manner. It doesn't say what that object was, doesn't say how close he got to the victim. Without anything further, there's no probable cause here.
It says it was a switchblade.
And I'm pretty
That
sure
doesn't
that's,
mean that it's necessarily a deadly weapon, and we don't know what was in his hand on this video.
he said he had a switchblade and the incident was captured on video. There's probable cause.
And I don't see anything about the victim saying that that she was in fear.
She stated she was scared as she witnessed the male in front of the store.
She might have been scared when she saw him in front of the store, but there's no indication that she was scared from that point forward. There's no indication that during the commission of this alleged assault that she was in fear.
So Mr. Reedy's arguing that she was in fear when she saw him, but her fear dissipated upon him pulling out a switchblade.
I think
says
without
she
something in the
stated-
probable cause affidavit to that effect, I
says-
think yes.
Excuse me just for a moment. It says she stated she was scared as she witnessed the male, which is later to be identified as Lewis, in front of a store. I made contact with Lewis, who was speaking to a security guard, stating he was at the store yesterday and got mad because they were following him and accusing him of stealing. He kept spontaneously uttering that he did not have a knife and did not steal. And then it goes on from there.
As I'm reading this, she stated she was scared as she witnessed a male in front of the store speaking with a security guard yesterday. So I'm not even sure when it is that she's supposedly afraid based on the reading of this probable cause affidavit.
The officer responded to an aggravated assault that occurred the day before. He wrote the report on the 13th. He responded to an assault that occurred on the 12th, the day before. The officer, again, watching the surveillance video, identified him with an object in his hand, which, based on the defendant's admission, is a switchblade, advanced towards the victim in an aggressive manner.
Based on his statement, he said he didn't fight anybody outside the store. And it looks like he didn't. And again, without any indication as to how close he was to the alleged victim in this case or anything further, or any identification of him having been in possession of a switchblade other than his own statement, and we don't know when he was in possession of this switchblade, there's no probable cause here.
I find there is probable cause. I'll take it into account. It's not the most artfully written probable cause affidavit, but in any event, what is it that you're asking for? Pretrial release?
Correct, Judge.
All right, where does he live?
It's 303. 313, Judge.
Southwest 14th Street, Apartment 3?
Yes, that is
All right,
correct.
no
Judge.
victim contact, direct or indirect, with the alleged victim. I'm taking into account, I'm gonna do a GPS open schedule. No bond required, thank you. Sir, you are not to return to. Does it even have a store name?
One moment.
If we don't, we can just give the address.
I can get the name.
No return to 1375 Southeast 17th Street.
Yes, Judge.
It's Ross, Dress for Less, and Obviously, this is over state's objection. I do believe Mr. Lewis poses a risk to public safety.
Uh-huh. Well, he's gonna be monitored, so. No return to 1375 Southeast 17th Street. This is the Ross store, and I want you, that's in Fort Lauderdale, and I want you to maintain. $500 from that address, including the parking lot and curtilage of the property. Do you understand?
Yes.
Thank you, sir. Good luck to you. Brendan Applegate, please. Okay, is this a medical reset again? I have no pick. Okay, medical reset, please. Dennis Nidro.
Mr. Nidro, come on up.
Good morning, Mr. Nidro. This is another MO case. Let's see who this is. Okay, Mr. Needlow, you have battery on an officer, firefighter, EMT. You have municipal ordinance violation. There's no bond attached to that. I'm sorry, yes, no bond attached to that. And you have a capious misdemeanor, which is a $50 bond for public nuisance, disorderly conduct. It doesn't say conduct. So what say you state on the battery officer, firefighter, EMT, with court does find probable cause?
Your Honor, I'd be requesting a $2,500 bond based on the allegation that he, spit on the officer while he was transporting him to the jail. He pled out 2017 battery on an emergency medical tech. He smacked a emergency room nurse in the face. He got 101 days, pled out October 20th of last year. Trespass 2016, failure to leave property upon order from owner 2011.
You're welcome, no problem. Okay, anything further? State, are you looking for something?
No, I requested a $2,500 bond.
Okay.
Judge, Mr. Nedro advised me he works construction when he can. And right now, he advised me he has family that lives in our community, sisters, brothers. Right now, he has no fixed location as far as where he lives. He says he occasionally stays with them.
My wife just died. I went into a coma. I mean, what else? Right now, I'm by myself. I have no responsibility.
Judge, from what he's saying, that he has no one out there right now to help post his bond.
And you're asking for?
I'm asking for him to be released, Judge, pretrial release.
When's the last time he had contact with the system?
Yeah.
What year was that?
He was arrested a month ago for failing to appear on a trespass, and he got out of jail. He pled out and was released on October 21st of battery on an emergency care provider. He was originally arrested on that case August of last year because he violated pretrial.
What happened with that case?
Pled it out.
To what?
101 days. He had time served at that point.
To a battery on?
An emergency medical caretaking.
All right, court has some concerns, so this is what I'm gonna do. On count one, I'm gonna set $1,000 bond. On the capious misdemeanor, I'm gonna appoint, I don't know what town it is, I'm gonna appoint Stephen Shate. That's on the capious misdemeanor one. And I'm gonna set a $1 bond on that. Does he have a phone number or something? Mr. Shea can contact him?
No, he doesn't have a phone number, Judge.
Okay, does he have a relative's phone number or something?
No, Judge.
Okay, thank you, good luck to you, sir, $1,001. Paul Sidlar, please.
I'm advised he's in court, Your Honor.
Okay, so should we reset him for tomorrow?
That's fine.
Okay, let's reset for 8:15, in court. And then we have Christian David Carmona Quinones.
Judge, she's gonna require a Spanish interpreter.
You know what, I called for one at the beginning of the
All right,
docket.
so let's just reset for 1 PM today.
All right.
And I think somebody needs to call Mr. Farnsworth, I think. Do we have any extraditions? I think. Tell them we need them here, if they could be here 5 to 1. Mr. Reedy, for extraditions, we need a Spanish interpreter. Pretty sure we do.
That I don't know, but we'll have one, because I'll call.
Can you
right
tell them
around
to
10
be here
1.
5 to, because you think we need
Okay,
them
yeah,
for
I can do that right now.
extraditions? Thank you. And if not, then we'll, Alex Miller?
It's Brian.
Anybody,
Conti, Your Honor.
anybody left at,
I don't know nothing.
anybody left at Maine?
5 to 1.
Emails have required a Chinese interpreter.
Let's reset them for this afternoon. I don't think we're getting one.
Okay, we'll reset for the afternoon.
I'm sorry, what happened?
The Chinese, we're gonna reset for the
I just
afternoon.
got off the phone with the interpreter's office. We can't determine whether they speak Cantonese or Mandarin. So that's 2 different languages, as the court knows. So,
So why don't they send one each? Hello, how
well,
are
that's
you?
what they're trying to find one each to do. But that's not gonna happen this morning, I can guarantee you.
No, I know that. So can they have them here this
They
afternoon?
will do the best they can, Judge. It
Okay,
would be helpful if the defendants could tell us which particular language they spoke. Well, thank you, ma'am.
And they cannot, Judge. We tried.
you did, okay. It is what it is, okay. So we need one each here. All right, and then we have, Alex Miller and Breon Bowens.
I'm sorry, what happened with Mr. Hilliard?
Mr. Hilliard is at Conti also.
Where's his paper? Did I give you Hillard? Okay, I'm sorry.
And these are
Yes. If you could just leave that the way, because I put Chinese on there, I didn't put Mandarin, but it's one or the other. Okay, Mr. Hillard, see ya at 1.
Hilliard at 1?
No, I was talking to Mr. Romero, I'm
Okay.
sorry, I should have said his name.
Okay.
Okay, so, Mr. Michael Hillard, you have robbery, no firearm or weapon.
1 second, ma'am. Let me see what this is.
Oh, okay, I'm sorry. Okay, Mr. Michael Hillard, is that your name, sir?
Yes, ma'am.
All right, good morning. We have a change of charge, count 1, to magistrate. You're being charged with robbery, no weapon. Before it was robbery with the firearm. Bond was $25,000, no victim contact, and that was by Judge Rodriguez. So there's a capious court does find probable cause. What say you, state?
Your Honor, I'm going to be requesting the same bond. The state had no objection to a bond being set, and frankly, I believe our position was that it would be a strong arm robbery, because there was a threat made with the gun, but there was never any gun recovered, a gun was never seen. And my understanding of the case law is that ultimately it would be a strong arm robbery, and that's what we charged.
Well, it's pretty clear Mr. Hilliard cannot afford the bond as set, Judge. Mr. Hilliard, can you afford any bond?
No, sir, I can't.
No, I'd ask for a $10,000 bond, Judge.
You know, and Your Honor, I would also just note, while he's charged with strong arm robbery, it is concerning. He's threatening a man and his wife, you know, that he has a gun, and they had every reason to believe him at that point, and they were concerned for their safety and well-being.
All right, well, I know you keep saying strong arm robbery, and I understand what you're saying, but I don't want to confuse him. It's robbery with no weapon is what it says on the capias, so if we could refer to it as that. Anything further, State?
No, Judge.
All right, what's the victim's initials?
1 moment. JP.
Okay, no victim contact, direct or indirect, with the alleged victim, sir, with the initials JP. Court will set a $10,000 bond. Is your mailing address 55545 North Federal Highway, Fort Lauderdale?
No, ma'am, it's 5555.
That's what it is, 5555. I said 4 5s.
Oh, okay.
Okay, I'm sorry. So 5555 North Federal Highway, Fort Lauderdale?
Yes, ma'am.
Is there any unit number or anything attached to
No,
that?
no.
No, it's a
Okay.
church.
Okay, so no victim contact, sir. Thank you. Alex Miller?
Conti.
Thank you. Okay, Mr. Miller, you have an add charge or a change of charge to burglary of a dwelling battery. Court does find probable cause. There's been an information filed. State, what say you?
Your Honor, you found proof evident or presumption great when it was armed burglary. I provided the court with the original arrest warrant affidavit. I'd ask the court to find proof evident or presumption great for burglary with a battery.
Defense?
In light of the fact that Mr. Miller is currently being held no bond on count 1, we would defer any argument regarding proof evident presumption great until such time as Mr. Miller can have a full Arthur hearing in front of his division judge.
Victim's initials, please. Any special conditions, just in case? If you don't want any, that's fine, but I prefer to at least have no victim contact. Sir, the court's going to order no victim contact, direct or indirect, with the alleged victim. The bond might be changed at some point, I don't know. But in any event, court's going to order no victim contact, direct or indirect. That means no contact in person, calling, texting, writing, nothing on social media. And more importantly, while you're in jail, no contact through third parties, okay?
Okay.
The initials are AG.
The initials of the alleged victim, sir, are AG. So, court is gonna find proof evident presumption great, no bond. I put that defense defers on any, proof evident presumption great argument, as defendant has a no bond hold on count 1, is that correct?
That's what I'm showing, Judge, yes.
Okay, all right, thank you, sir, good luck to you. Next one is Breon Bowens.
Mr. Bourne was removed off the docket, so he should have been placed on.
Why was he removed?
When?
Why?
Because he was remanded yesterday in custody, served with the capias, and the judge ordered him to be up.
Okay, so this we're gonna delete from the docket. Who's the judge?
Cora.
And he did what? Did a no bond hold?
Yes.
For what? Violation of pretrial or on this charge? Okay, pull up this case, thank you. All right, there's another gentleman that was not sent to the receiving center today as well, is that correct, Michelle?
Another woman, yes.
And who was that?
That is Beatrice Zerker.
All right, I'm gonna have to look that up. Okay. Court's in recess till, can you have him bring the extradition